These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
Let me see, Jack. Let me get this.
Okay,
we're going to talk about what here this morning a little bit?
Okay. We're on Sunday morning. We're in the Boston seminar. We're starting to talk a little bit about the money issue, and we're dealing with how money is created. We've been talking a little bit about contracts originating either in the republic, the private side, or contracts originating in the public, which is the democracy. And the issue came up that you can have public contracts, public-private, private-public, and private-private. So the question is then, what are we talking about with respect to those kind of contracts? And we said that the first word, either public or private, tells us which jurisdiction the contract is coming out of, so that the law of that jurisdiction deals with that contract.
In an oversimplification,
yes.
A contract coming out of the private side or a contract coming out of the public
Correct.
side.
The second term then determines whether the contract is between individual parties within that jurisdiction or whether it's between an individual and what might be considered public knowledge of those contracts or a public interest of that contract. We used an example that if it's a public-private, it's coming out of the democracy, which would be a contract, let's say, when you're straw man.
How about use it with a policeman stops me? And aren't we making a contract? Is that from a public to a private?
The policeman comes from the democracy, so he wants to write his contract or associate with you in the public. So it starts out of the public. At first, though, he is just privately talking to you. So it starts out public-private because he's dealing with you in an investigatory manner, and he's not sure that anything you've done affects the public at all. But if he charges you, then that contract gets filed in a public records office, i.e. a traffic court or a court. Now the contract is public-public.
Let me clarify this. So he comes up to my window and he says, "Sir, you're doing 82 miles an hour." It's still private at this point.
Yes.
Okay, so we're just having a conversation. He's kind of making assumptions, presumptions, et cetera. And he says, "You ran the red light," or whatever. He's kind of making an offer, and if I give him what he asked for, a license and some registration, we're still kind of in a private. But when does it go public?
When he files his charging instrument in a public government office.
So even though I signed the ticket, it's still private?
Yes, but he's going to register that in the public, and now it's public knowledge.
So it's really kind of, I kind of know, if he just talked to me and warned me, we stayed private. But if he writes me this ticket, I know he's going to go file it with the public. So
Correct.
Right then and there, I'm already knowing this thing's going from private into the public, right?
Yes.
But it actually hits the public when he files it.
Correct.
Because he might tear up the ticket, right?
But remember, we've been saying all weekend that aren't contracts dynamic? They change. So if the police officer puts the charging instrument into the court system and makes it public, then if our straw man goes in and tries to defend it, it stays a public contract because your straw man is in the public. But if you go in there now as the secured party creditor and you do an acceptance, what you're trying to do is remove that public contract back over into the private to deal with it privately.
So I started out private, it slipped into the public, and I got to try and get it back into the private.
It back privately to try to resolve it.
All right.
When we do it in that fashion, okay? So then there was a question out here that said, dealing with public, private, etc., if you go out there to buy land or property, what area of that contract are you dealing with? And remember, the issue that we're dealing with here is that with the trust, the birth certificate trust, the presumption is all of the collateral, all of the, quote, property, is going to be dedicated to that birth certificate trust. It's not dedicated to the living man at that stage. And so when you go out and you buy a home, it's going to be deeded in the name of the straw man, which in our dual trust was box 6. He's going to be the owner of the property. But remember, ownership means he's got an equitable interest. He has not got the legal title. And with an equitable interest, an owner is a debtor, which is why the owners of these properties are below that dual trust line. It's in the public trust. Remember, Rockefeller said, own nothing, control everything.
How would I own a home? How would I not own a home but control it then?
Well,
help me. You got me a little confused here.
Haven't we said all weekend that you are not the debtor?
Yeah.
If you think you're the debtor, then that's who you are. That's the role you're playing. We are really box 1 and box 2 if you want to act in the role of the creditor. Box 1 is the underwriter. It's your spirit. Box 2 is the creditor bank, and he is the surety in commercial terms. And so your underwriter, box 1, can either energize box 2, your creditor, or he can energize box 6, your debtor. But he cannot energize both at the same time. So in the past, what we have been taught to do as good public citizens and debtors, we have been taught to let our spirit operate our debtor side of that trust. What we're trying to teach you this weekend is understand you've got choices. Let your spirit operate the creditor side of your trust. We have indicated to you that if you are in the private world, the republic, and you stay with your creditor, doesn't your creditor have signature access to a bank fund in the private to which you almost have unlimited units of currency that you can use to set off and close any one of the debt accounts that are picked up by the debtor straw man?
Isn't your signature just the money?
The signature is the thing that moves the money. Moving money is currency, and currency moves from a creditor to a debtor in order to be able to settle an account. Yes?
So does that mean...
Now that we're on tape, it would be good to have the mic.
Does that mean right now that since I understand the private side, if I have real estate transaction, I still use the straw man public side to go do the transaction and then come back, use a private side to set it off?
Yes.
That is the whole...
In other words, let's look at it this way. In the past, you truly believed that for your straw man to purchase a home, the straw man had nothing called money in order to pay for it outright. What you could understand now is if you could get that straw man out there to induce a seller to give you a contract to purchase that home, can't you then turn around and have your creditor go to the DTC, get your funding, and set off the cost of that home entirely? So that in essence, when you are operating, the spirit, box 1, the underwriter, is providing the signature to energize the creditor, box 2, the surety. You are funding whatever you want to fund through that surety. And what you do is your surety can loan the money to the straw man to buy the house. Because as box 1 and 2, you are what's called an investment banker. You've got to look up these terms in the dictionary. If you look up banker, investment, you will find out that an investment banker does not loan money to the public. However, an investment banker sells equity to raise currency. And when he raises the currency, which is what you're doing when you're pulling the funds out of the DTC, you then loan that currency privately to whoever on the debtor side wants to own something. But you're not going to go down there and own it. So let's say you don't want your straw man owning anything, but you set up an LLC in order to be the owner of this home that you want your straw man body to be living in. He's got to live somewhere. He's got to have shelter over his head. So you set up another vessel, a fiction, to do business like an LLC. And the LLC is going to purchase that home. And where is he going to get the money? He's going to get the money through your secured party creditor, box 2, which got the funds from the DTC, who loans him the money to purchase this home. So is your secured party creditor going to be an owner on the deed? No, because he cannot go down into the public and register a deed. Otherwise, he becomes a debtor. But he can loan the money to the LLC, and the LLC can register the deed. What does the secured party creditor do? He goes on to a UCC 1 or 3, and he puts a recorded lien on the LLC on the description of the property because he acted in place of the public bank. He loaned the money to the purchaser down here in the public. You see what's going on? You are a bank when you understand who you are in your mind. And as a bank, you don't need the public banking system. That's why they resist everything you're trying to do, because if you understood who you were, you would totally obsolete every entity that's created in this public system to control you. Now you said, why don't you just take that property yourself? You could if you acted only as block 1 and you were not divided into a trust. But because you were divided into a trust at birth, you have no capacity to allodially hold the property as long as you're divided into a trust. The trust that divided you was the birth certificate trust. So if you want to go back to allodial ownership of property in only your own name, your own capacity, you have to first collapse the birth certificate trust. Because as long as that trust is there, there is a security agreement in the background that prevents you from holding any estate. You understand?
So the procedures will be once the account is set off, on the public side, they have tax record, they have title. Those things have to transfer it to LLC or...
Let the LLC, which is a fiction, be the registered owner. He's a debtor.
Or still under the straw man name.
Yep. Well, it could be the straw man, or it could be an LLC with an entirely different name.
Okay.
Either way.
I think I got it.
Okay. Yes, sir.
You keep it say box 1, box 2, 6. Can you clarify a little bit?
That was the diagram, the dual trust diagram we went through the other day. There should be a download that was given to you that had that file on it. And when you download that dual trust file, you will see that what we put up here on the screen and talked about was slide number 12. There's actually a sequence of slides that develop that whole concept, but slide 12 is what we use as an abbreviation for this particular seminar. Okay? The topic a little bit was how does this money thing go? Briefly, so that when Brandon is talking about the set-off in terms of this administrative process, you can really see what's going on in the background, the transactions like in a mortgage case that set this up. And so let's go through that real quickly, and then after the break, Brandon will get back on here and show you more about this administrative process. Now, in the mortgage deal, it starts out because you have a living man over here on the right-hand side, the Republic. And what he does is he writes a note. And this note is a negotiable instrument, promise to pay to the order of bank. If you're going to borrow, let's say, $1 million for your mortgage loan, the note is face value $1 million. Promise to pay to the bank. Now, that is a contract that you signed with the bank when you went out to do a mortgage. If you purchased an auto on loan, I guarantee somehow or other you signed a note which was part of that purchase. If you're working with credit cards, your credit card application was a promise to pay back the bank whatever it is that you pulled out on funds on that credit card. So somewhere you created a note which was a promise to pay the bank. And that is the foundation of the, quote, money, unquote, that the bank is lending you. The bank had no money. It's in the public. They needed to get the source of commercial energy from you, and they induced you to sign that note. That note was signed on the right-hand side. The signature on that note was the signature of the secured party creditor or the authorized representative for him. Yes?
Can I term that note also as a security debt?
The note is a security. It's an agreement. It's a two-party security. Okay? And the note then is passed over basically onto the public side to the mirror image, which is your straw man. He gets that note. And he passes that note down to the bank that he is negotiating with as the loan that's going to be applied to purchase the home, so to speak. Well, look, if you have the capacity to create the money, the point we're making is, why do you even need the bank? Well, the problem is you need that bank because if you're going to want to have ownership of that home, ownership is on the liability side, not the asset side. So you've got to go through the public here in order to create the titles to register into the registers so that it looks like you've got the title to the property, because that title's coming in the public. Okay? So the $1 million goes to the bank. The bank looks at this note and they go, well, we don't want to circulate private money here. We're in the public. So they've written up under the Uniform Commercial Code, negotiable instruments are in Article 3. It looks like you're dealing with an Article 3 negotiable instrument. But they've written into the code that if this instrument is being tendered for transactions that are going to extend beyond 9 months, they define that instrument, even though it looks like it's an Article 3 negotiable instrument, they define it automatically to be not a negotiable instrument. It is now a security as defined under Article 8 and under Article 9 of the Uniform Commercial Code. So because it's a security in this world by their definition, it cannot pass as a negotiable instrument and be money. They will not accept it as money. So what they have to do is they treat it as a security. When you have a security, the bank goes through an SEC, a Security and Exchange Commission licensed broker. Yes?
I'm a little lost on this.
Try to get a mic. Or a mic that works. He's got his lavalier mic on if he's up and running.
Anything yet? Here.
There we go.
Never mind. I'm a little confused, Jack, regarding, are you telling me that anything less than 9 months is a negotiable, and anything after 9 months is non-negotiable? Is that what you're saying?
That's the way
explain that a little slower for me, will you?
That's the way they define it in their system. But you see, if a bank's going to be dealing with you, they're signing you up for a long-term loan. They're not signing you up for a 30-day rollover. And so if you're involved in real estate purchase, car loans, credit cards, these are all revolving accounts every month that go well beyond 9 months. So the bank won't deal with you with a security instrument unless they're dealing with you on a long-term contract. And it's for that reason, because they don't want to see that instrument as money. They want to see it as a security. They take the security through an SEC licensed broker who the government authorizes to sell securities. To whom? They present them to the Federal Reserve Bank. The Federal Reserve Bank has a public window, it has a private window, so it's on the line between the public and the republic. The SEC broker tenders your note, which is a security for $1 million, to the public window of the Federal Reserve Bank. The Federal Reserve Bank says, well, what's the Social Security number of the guy who is passing that note? And what the Federal Reserve Bank does then is they go to the DTC, Depository Trust Company. And the DTC is basically a registry of all securities. Isn't your birth certificate a security? So they know you have a birth certificate account. And they hold the information of that. And each of your 10 Social Security cards are 1/10 of the estate of the value of the security of that birth certificate account. When they get the note and they know the Social Security number, they look up your account, and if you have an account with them, they approve the purchase of that security at face value. Why? Because you only have an account if you have a registered birth certificate. So if you're an illegal alien coming into America, you've got a birth certificate, but that's down in your country. These banks probably will not deal with you because it's not a registered account through the United States. But since you have an account there, the Federal Reserve Bank passes the security to the DTC who deposits it in your account. So if your account had a balance of $1 billion and we now take in your note, the account is just incremented by the face value of whatever's on there. So now your account is $1 billion, $1 million. The account just went up because they deposited the asset of the real man. So this real man could have just come on over to the DTC and said, take my instrument. But he went the long way around because they don't want the real man knowing about all of this stuff that's on this side of the republic. Because he still doesn't know how to operate as the creditor. He keeps operating only by underwriting his debtor. Box 1 underwrite 6 instead of box 1 underwriting 2, which should be able to go straight to the DTC accounts. So this real man, box 1, still doesn't understand quite how to do business. He's got to go into the foreign land of the republic to get all of his business transacted. Whereas in reality, he was set up by God to stay in the republic and do business over here. But we're stuck with what we got. So as soon as the DTC increments the account over here by plus 1 million, isn't that just a piece of paper that went in there? Was there any substance in that paper? No. So what do we got to do? Because in reality, we got to keep the balance of things in nature. So if one thing gets plus 1 million and tips the scale down, since we haven't done anything of substance, we got to do something else to bring the system back to level. So what they do is they create a drawing account over here. They put the 1 million in this liability drawing account to offset the new increase in the asset account. That 1 million then is debited out through the Federal Reserve. The Federal Reserve writes a check for $1 million to the SEC broker. The SEC broker sends the check to the bank minus its fees. The bank now has $1 million of public currency, its liability funds. It puts it in an account. So it now puts a plus 1 million in a checking account in the name of who? The straw man, not the living man. On the outside, the bank has a security agreement with the straw man and the bank, whereby in this security agreement, both parties have agreed that the straw man is borrowing this $1 million and he will pay it back to the bank. In return, this bank will now draw a check out, and whoever the seller of the property is, that 1 million goes through escrow to the seller. The seller's happy and walks away. In return for getting the million, he surrenders title to the land. Because remember, we go through currency to title to possession. So what has just happened here is our living man has created currency. The bank accepts a security, which is a title. Then it takes the title and it sells the title for currency back through the private side. Then it's got currency, so it loans currency to the straw man so that the straw man can purchase title. At this stage of the game, contract 1, your living man loaned the bank $1 million. Your living man signed on the right side, he's a creditor. Then your straw man was induced in the public to sign a security agreement to borrow money from the public. He signed that contract on the left side as a debtor. The bank now, under that contract, has, since it loaned money, it wants to get some security, which is a title, as a surety for the payback of the money. So as part of this security agreement, the bank induced the straw man on the left side, in addition to the loan agreement, the security agreement, he induced the straw man to do what? See, when the seller got his money, the seller gave up title, and this title was a warranty deed. And the warranty deed went to the straw man, not the living man. Because the money that bought that title was out of the public. There was no title, legal title to that money, only equitable title to that money. So the straw man only got equitable title, which was possession and right of use. He did not get the legal title so that he could control the land. Had the title been purchased with the currency that could be on the private side from the living man, box 1 and box 2, that money, asset money, would have the equivalent of legal and equitable title. And when that currency went to the seller, and the seller gave up warranty deed, then what kind of titles and rights would be in the property that was purchased by the living man through box 2, the surety? He'd have a lodial title, because the currency that purchased the land was both legal title and equitable title when it comes out of the DTC. Yes?
On the charge, can you explain this? On the charge, can you explain?
Are you on?
No.
Turn it on.
Yeah.
Did you push it up?
Yeah, it's up.
Okay. Just a sec. Keep speaking.
Okay, on the charge, I speak a little bit louder. On the charge, can you able to explain? Right now it's the procedures. After the charge off from the charge, do that thing move back to this side?
When we're done with the mortgage? Is that what you're asking?
Yeah. Let's say the mortgage is
Haven't
done.
gotten there yet. We'll get there.
Okay, I just
Okay.
want to see the
I'll
charge.
show you how it goes all the way around the circle.
Okay, the second question is, I remember 30-some years ago when I become citizens, they took my ID, they took my passport, they took my birth certificates. How do I find out that, am I registered
Yes,
under
you
the
are
DTC?
in the DTC. What happens is your birth certificate is still registered with the country in which your body was born.
Okay.
Okay? When you move citizenship, you move the accounts in the DTC on who is controlling those funds for the straw man. See, right now the United States has absolutely an open border policy, effective, although their law says we've closed the border and only those people that under the law can get in, get in. But the reality is, as you see playing between the feds and Arizona right now, is it's an open border. Anybody can come in. Why are they doing that? Because they want every one of these people to come into America, but then once they get into America, it doesn't do the United States any good until what happens?
Register.
Until they're registered here. And so for a period of time, they open up the borders, and then every 5 or 10 years, what do? Amnesty. Just register here and you're good to go. They may fine them, they may do whatever they want. They don't care. What they need to do is register you, because if they register you, what does that mean? They've added more people into the trust, which was box 3 on the private side. All their estate now goes into a trust, and that trust is now attachable by the Secretary of Treasury, U.S., for the purpose of funding the corporate U.S. So the more a nation gets industrialized, remember we said yesterday that in the public system, the banking system, the money system is a zero-sum game. It is designed to fail for the people. And because it's a zero-sum game, in order to keep the game going, they got to keep bringing in new energy all the time. If they're not bringing in new energy, it's going to fail even quicker. It's like a Ponzi game. And they need to keep piling in new sources of currency. And the way they're going to do that, since Americans basically have a zero birth rate growth, what they need to do is bring in aliens, foreigners, anybody that they can register in order to keep the Ponzi game going as long as they're trying to build up that system before they crash it. And so you follow the money, you follow what's going on. It's simply financing the federal scheme of things, which requires new currency, and that requires bringing in as many people from outside as you can. But then you've got to get them registered, because if you don't get them registered, if they come to America and they earn all of this currency and they send it home, who's getting the expansion in terms of the economy? Their homeland, where their birth certificate is currently situs. So when you come here, when they register you, they do not move the birth certificate, but when they give you the citizenship card, they've moved the accounting of your birth estate from the country in which you were born to the credit of the United States now. Yes?
At what level of government are they aware of this?
At whatever level they've either learned it on their own or have a duty to understand it to do their job. It's the military. In the military, they do not train anybody above the level that they need to do their job. Otherwise, you will give too much information to the enemy, and that will cause a major problem in your system, because your system operates through stealth and secrecy.
So all high positions in all nations.
They would know this.
Okay. And second question. I noticed that you said that when the money moves or whatever, that $1 million moved back to the private side, then the man's asset increases by $1 million.
On the private side, because he created $1 million. And that creation is recorded in the estate, birth certificate estate that they're keeping for him. So the private money is recorded on the private side. It creates the mirror image of a reflection creation of $1 million on the public side. It's kind of like, remember when we said the dual trust? Above the line is the land, it's the mountains. The line is the shoreline. Below that is the water, but you see a reflection of what's in the land in the water. It's only a reflection. It's not real, but it appears real. So you've created private money in the private, which is recorded in the private. But the reflection of this money creation on the land appears in a mirror image in the public, and now there's $1 million created in the public, which is circulating.
So, for the guy who writes a lot of bogus checks or use a lot of credit card,
Correct.
Is that the same? Does that also include?
If he creates an image in the Admiralty Maritime in the lake, there is a reflection of that image actually into the private side, the Republic, because they got to zero out, because you can't create something that is real in a fictional world which doesn't have a consequence in the actual world to cancel it out or to create the fundamental presumption that there was something there to allow that creation. Now, if you create a counterfeit check over here, the counterfeit check goes into the bank or the government. Doesn't the bank or the government got to zero its books at midnight? So where are they going to get the set-off for those counterfeit checks in order to zero their books? Where is it going to come from? It's going to come from your DTC account. They're going to zero this creation of counterfeit money by debiting it from your DTC account. You don't even know it's coming out of there, right? No. But did this living man give an authority for that to come out of there? No, there's no signature. What did we say yesterday happens? We showed you that there was reality up in this line where the guarantor or grantor and the trustee had a duty to pay a debt from somebody in the public. If they didn't pay that debt, they created a court trust as a fiction to resolve these transactions. And that court process was in essence a probate court, because since you weren't doing your job up here, you must be dead. So they created a mirror image down here in the public called a civil court, and they went and charged your straw man. When they charged your straw man, could your straw man as the defendant come in here and have access to this court? No, he's dead. So they treated him as dead, and they just went ahead and took care of all the business. And in order to pay that beneficiary, they debited whatever it took out of his public estate in order to pay off his public bills. So what's happening here is if you write a counterfeit check over here in the democracy, they have to set it off by midnight by going to your private account to zero it. But since the living man didn't authorize that properly, what ends up happening is that the public system steps in like in probate and goes, we got a problem here. And what they do is they create a probate court called criminal court, and the criminal court charges the straw man on the counterfeits. And when they collect the money from the straw man by the conviction of the counterfeits, what does that money do in part? It reimburses the private asset account, so we're back in harmony, but then we penalize the straw man over here for not going through the proper balance. Isn't everything in life balance? You got to balance the yin, the yang. And if you don't balance the reality and the fiction, something's out of balance. And if you don't resolve that because you don't understand how, they will step in as the trustees and balance that out. But they're not going to explain to you what they're doing and why they're doing it. It's just that easy. I'm giving you the roadmap in the money system to show you why your straw man's charged civilly, why he's charged criminally, and when you understand that this living man has the capacity to go in and resolve all of these issues, if you know who you are and stay in honor, you don't have a problem anymore. Like Brandon says, all I've got is solutions. You don't have any problems. The problem is your straw man, and the only reason he's got a problem is because your spirit looks to the fiction to guide your life. Is it making sense? And so after we're done showing you here today, then the administrative process that Brandon is showing you makes sense, because his administrative process stays in the Republic on the private side. And it stays with the box 1, spirit of the living man, dealing with his own trustee, box 2 creditor, who has access to the funds in the DTC, which they removed from the public in 1933 because the public is in dishonor and doesn't know how to practice law. And until you understand law and what you need to do, you do not have direct access to this account because you're incompetent. Question?
Yeah, Gordon's been saying that this is government. We have a perfect government. This isn't government here, right? This is the Federal Reserve we're talking about.
No, wait a minute. Where does government start?
Well, this is what I'm saying. Federal Reserve is a private organization, right?
You are the start of government. If you cannot govern yourself, someone else will govern you. The thing you call government should be right in this head and right in this heart. But since you cannot govern yourself, you will be governed by a trustee or others.
But who said I can't govern myself?
You obviously can't govern yourself because every day you are in total dishonor. Your actions and your conducts prove you are not capable of governing yourself.
Well, that's because I didn't know this. If I knew what was correct,
If you were capable of knowing this, then you would be eligible to govern yourself. Ignorance is no excuse. Oh, I would be competent if somebody made me competent. Excuse me, that's an oxymoron.
No, not made me. I mean, I understood their scheme.
You're not on the tape, Mel. Okay. Let's finish this so we can get over this. This was really off the seminar.
Jack,
we're filling it in. Yes.
One quick one. Is the bank charter what gives the bank the authority to...
Yeah, the bank is chartered in the public
And that's
to
what
act
gives
as
it
the trustee.
It's like a permit to make money? Or
Yeah, it's licensed. Isn't a license permission to violate the law? Every license is permission to violate the law. So the bank's licensed, the SEC broker's licensed, your straw man's licensed, the people that register these deeds are licensed. Everybody on the public side is licensed. They're all violating the law. But you participate in that system. Because you're participating in the system, you're getting a public benefit and you have absolutely no standing to question legally or commercially what's going on. So start understanding it so that you can choose wisely to either operate under the license or you can choose to exclusively operate in the private, where you're in total compliance with the law. That's our point this weekend. Okay, so right now the straw man has got a security agreement and he's given the bank a title. It's called a trust deed or a mortgage deed. If you look at the title, you will find out that the title is under a statute staple or a sheetar. There is an article that's in your 4-file download from the other day, dealing with an article called the sheetar, which is a Georgetown Law University write-up by an attorney, Judith Shapiro, in about the year 1987. She is explaining to you the history in the Western worlds of titles that are called statute staples, which are death contracts to your title in the land. If you go back to Scripture, you could never alienate permanently your title in the land. In the Jubilee year, even if you pledged your land to the bankers, you would get title to your land free and clear back to your family. You could start over and pledge it away again, but every 50 years it was automatically redeemed. Well, the bankers didn't like the fact that at the end of 50 years, you'd automatically get control of your land, so they created back in about the year 1080s, 1090s AD in England, they created a form of contract called the statute staple or the sheetar. This contract is a death contract. It waives your rights to return your title in the year of Jubilee. And it does it legally in such a manner that once you lose rights, titles, and interest to the property under that contract, you cannot ever gain them back again. So the issue is, if the true law says you can never lose your title to land, but in the law over here in the public, in the fiction, you can be induced to sign a death contract, and you do it. And remember, doesn't the law assume that if you're in commerce, you know what you're doing? It's an assumption. So don't go telling me I didn't know, because the law says that people that act in commerce are assumed to understand what they're doing, and they're assumed to read the terms and conditions of the contract. So when you sign a statute staple contract, you're agreeing that all rights, titles, and interests are forever gone if you do not uphold that contract. In a legal sense, you've got the warranty deed, and on top of the warranty deed, you've got the mortgage deed or the trust deed. The mortgage deed or the trust deed just did what to the warranty deed? It just canceled it out. If you don't fulfill the warranty deed or the trust deed, you have agreed through the statute staple contract to abandon all claims to your property. So Brandon told you yesterday, yeah, but you really got the warranty deed. Not unless you deal with that statute staple, you don't. Because you have canceled the warranty deed, and from a legal point of view, that warranty deed is an abandonment of the property if you do not fulfill the contract under the mortgage deed or the trustee deed. So you can't come back and say, but I got the first recorded interest. We've got the superseding signature on your signature whereby you agreed to terminate your title. So are these banks doing anything wrong? No, but you don't know what you're doing. So read the Sheetar article. It will tell you what you're doing. Now it will tell you flat out that you can cancel the statute staple. Remember Pinocchio? There is an escape clause. But where are you going to find the cotton picking escape clause? It is really hidden. I'm telling you, if you read Judith Shapiro's article, she's given you the escape clause. And I will give it to you this morning. If you're nice. But you guys are all nice. Okay? So where we are right now is this bank has exhausted this account of $1 million. They want this straw man to fill that $1 million account back up. If they fill the $1 million account back up and you fulfill your contract, then the bank debits that account, zeros it, sends $1 million check to the SEC licensed broker. He presents the $1 million check to the Federal Reserve Bank and says, we want to redeem the note. So they pay in $1 million to this account at the DTC, which is the account they debited to loan the $1 million originally to the bank. You zero this account now at the DTC. Since that's zero, you've got plus $1 million. It's out of balance, isn't it? So they take the asset note out of that account, debiting your asset account at the DTC by the $1 million because they're removing the security for $1 million. The accounts are now in balance. The note comes back through the Federal Reserve Bank to the SEC broker to the bank, which returns it through the straw man to the living man, right? Not. Does he ever get his note back now? No. I'll tell you why in a minute. But that's what's supposed to happen. Now look at it this way. Isn't the living man supposed to be the creditor over the estate of the straw man? Right? But now that we've paid off the mortgage, doesn't the straw man have ownership of the property free and clear? In equity. If the living man now put a lien on that house, for how much? $1 million. How did the straw man gain or lose anything in the transaction? He created $1 million by a note, which was just a piece of paper. All the way through this transaction, he had a $1 million asset increase in his DTC account. After the loan was paid off and the title was in the name of the straw man, he put a $1 million property lien against that property. Now, isn't his asset? It was $1 million in a security. Now it's a lien hold interest of $1 million on the collateral. Has anybody screwed the living man? Has anybody screwed the straw man? No, they're not. Okay? Because in reality, how did his assets rise by $1 million in the real world? The commercial energy of the straw man, making payments back to this bank over 30 years, generated a new $1 million asset for the trust. But ultimately, in the real world, where did the increase of $1 million come from? The labor of the living man. Nothing changed in 1933. They banked, and the government did not give you anything for nothing, basically. All they did was change the procedure. But you're so confused, you don't see how the procedure changed. The total sum of all of the net worth in the world is not in the accounting systems per se. It's in the creation of what man does intellectually or physically. And if you think that the DTC has got $40 billion for every man, woman, and child on earth, then tomorrow let's just turn them all loose on their account. Would anybody work anymore? No. Would there be the production of any food? No. Would anybody show up to keep the electric generators working? No. Because man is going to follow the easiest path. And if you give them the easy path of writing checks out of an accounting system, no one will do a damn thing. Which shows that people are not competent. If this system works, and it's the damn best system in the world, if you know about this, and if you're given access to that, the only way it's going to work is because tomorrow, after you find out about it, you're going to do the same productive effort tomorrow in society as you're doing today. And if you think you're going to retire because you're rich now, this system will collapse within a week. All they did is give you the perfection of a system, non-commercial, appearing commercial, to imitate what's going on, so that over here, isn't there the unlimited capacity to generate a commerce, only depending upon what you create, but then what you put into the system in terms of your intellectual and your physical capacity. But they give you a monetary system which can expand unlimited to be able to allow you to produce goods and services to the limit of what your physical and mental capacity can do. This is not a get something for nothing program. It's taking all the stops off of the monetary system which exists in this world. This is a zero-sum game. Over here you have a positive-sum game. The future is only limited by your mental and physical capacity to produce. It's not limited by the banks. But it's not a go to the well and get something for nothing either. We've got a limited time. We want to cover a couple of more things. So you can see how this thing comes back. Okay, here's the problem. If it comes back, we cancel the mortgage deed or the trust deed. We're back to the warranty deed. But see what's happening. Everything is selling currency to buy title or selling title to buy currency. If you've got title, you've got right of possession. But title could be equitable and legal. So that's a complication we throw in. Legal title is only possible in the private, in the republic. Legal title is not possible in the public, except that the public government assumes legal title, because if legal title is abandoned in the public, the law of escheat, everything that is not legally title provable goes back to the government as a trustee, is the presumption. Now let's see how we can get out of some of these problems. For instance, didn't we get into the problem by the living man creating a note? Well, if he can create a problem with a note, can he create a solution with a note? If the living man produces another $1 million note, and he passes it to the straw man to pass to the bank, and he says to the CFO of the bank, here is a new $1 million, take care of that old debt. Isn't the A for V, isn't the Doug Riddle passing to them new money order? The question is the money order passing via the public, or is the money order passing through Doug Riddle or through the IRS, as Brandon is showing, not through the public, but through IRS on the private? If they pass it through Doug Riddle or IRS on the private, then what you're doing is you're putting through internal revenue. See, internal revenue works between the FRB, the DTC, and the IRS. And the IRS is judicial. The DTC is legislative. It keeps the books. The FRB is executive. It passes the currency, which creates the energy. And the IRS is judicial. What does judicial do? They are auditors. They are accountants. The purpose of the auditor is to determine what property is the public's and what property is the private. That's what the IRS does. If you file records with the IRS showing your private, are you a creditor or a debtor? Creditor. If you file forms with the government IRS showing your public, what are you? A debtor. Can you file a 1040 return for the straw man and be a creditor or a debtor? Yes, in a respect. If, let's say, the public has pulled a tax, but let's say that tax wasn't due because the creditor already had prepaid it. If the creditor already prepaid a tax and the straw man was either induced or forced to pay that tax, can't we get a refund by filing a 1040 return? Because the tax was paid twice. And the only way to get any money back from the government on the IRS, theoretically, if money was paid in the public that shouldn't have been, is to file a 1040 for a refund. Is the straw man entitled to the refund? No, but he is, and if the living man is controlling the straw man through the creditor, and the creditor paid the tax, then the straw man also paid the tax. There was a double payment. And the living man, doesn't he put the signature on the return for the straw man? Yes, the energy. He can induce this 1040 return to go in asking for a refund, even though it looks like it's coming from a debtor. That's what the 1099 OID process is about. But that's not our topic today. But if the living man can do something through the IRS to go directly to the DTC, let's look at it this way. If this bank has not paid off the mortgage, your straw man hasn't paid off the mortgage, isn't there a plus $1 million account up here? If we could directly access that plus $1 million that was set aside for this mortgage to begin with, couldn't we have the Federal Reserve transfer that to the bank to set off what's still due? And if plus $1 million comes out against that liability account minus $1 million, whatever's left, doesn't that go to zero? And the mortgage is history, and the bank has to be induced to release the title. So that's, in essence, what Brandon's administrative process is doing. He's going directly through IRS to get your asset fund to come back to this bank to zero out that liability. But let's say you're not ready to do that, or don't understand it, or don't want to take the risk. All you got to do is write a new $1 million note. When you tender it to the bank, does the bank ever return your new note? No. What do they do with it? Same thing they did with the other one. They give it to the SEC, go to the FRB, sell it to the DTC. Now you've got plus $2 million up here, and you got another $1 million drawing account. That million comes back through the Federal Reserve Bank, through the SEC, to the bank, and it pays off whatever was owing on that first note. But now, don't your straw man owe something on the second note? He owes as much on the second note as he ended up owing on the first note, didn't he? So you're going to say, well, gee, that didn't do anything. Well, it didn't do anything if you didn't read the article on the sheetar, or if you didn't understand the Uniform Commercial Code. Because the Uniform Commercial Code says a new instrument given, tendered, for payment of a pre-existing debt, sets off the pre-existing debt to the amount of the new tender. You've got more than enough in the new tender to set off the mortgage debt. So you set off the mortgage with the bank. Why doesn't the bank just surrender the mortgage deed or the trust deed? Hang on. The answer is they have to. Because if you go to the sheetar article, it says that when you set off the pre-existing loan contract, it cancels the underlying contracts. What did we say the mortgage deed or the trust deed was? It's a death contract, a statute staple, preventing you from redeeming title. But isn't that the underlying contract? Absolutely. So what just happened is you canceled the death contract. But you still got a simple loan. Now the UCC says when you did that second one, you've canceled the remaining debt. The underlying contracts aren't part of the underlying contracts is you've got to pay on the unpaid amount of the loan at 5% or 10% interest. That's part of the contract that was canceled. There is no more contract to pay interest. And it also cancels collection fees. There's no liabilities for attorneys trying to come and get it from you. But the fact is you still have a simple debt there. But you owe only principal. You do not owe interest. You do not owe collection fees. But the reason they continue to move on with the foreclosure is they're not foreclosing on the original contract. They're foreclosing on the simple debt that you have left that is unpaid on the first loan, which is rolled into the second loan. So with the payment here on the first loan, they will actually go back through the DTC, retire your first loan, and redeem your first note. If they redeem the note, which is the currency, that currency has bought back that contract on that statute staple, because you go from currency to the purchase of title. But since you've got a simple debt here, they don't want to tell you what you just did, because everybody will get out of their death contract. Nobody will owe interest to the banks. And now the banks they've got to pull their mortgage deed and trust deed out of the recorder's office. Do they pull that deed out? Yes. How do they pull it out? They go through the assumption that they sold the title under your last mortgage, so that colorably it looks like we've got to pull that trust deed or that mortgage deed out because we already sold title to someone else. And it's no longer relevant. But they've convinced you in your mind that the only reason they pulled it out of the record is because everything you did was a fraud, and they continued what they were doing. Why do they now go for possession when they turn over title to whoever purchased it from the trustee or the sheriff? Remember, didn't Brandon tell you they were getting a raw deed? That they only get what was there to be given. What was there to be given is no longer a statute staple, which will convey rights, titles, and interest to the new purchaser. Because you cannot convey rights, titles, and interest, because your rights, titles, and interest were protected when you killed the statute staple contract. So the deed coming from the sheriff or the deed coming from the trustee will not guarantee any title against these people as long as you've given them at least a note. They will take possession because, like Brandon said, they need possession to make their title good. Everybody in here understand common law lien? Which jurisdiction does a common law lien fall on? The public on the left or the private on the right? Private on the right. If you look up the definition of common law lien, it'll flat out tell you it's not based on statutes. It's based on the ancient common law of practices among merchants. So you've just gone over to reality. Man, if there's one thing Admiralty Maritime courts hate, is having to get out of their jurisdiction and go to reality. But because you induced them to do that, when you paid off the old note with the second note or with the process that Brandon is showing you on the private, they've got to cancel the lien. Well, they don't want to, but they've got to because their own statutes tell them. And their own attorney, Judith Shapiro, in that article told you the history. And she says as soon as you send a second note, you have basically discharged the statute staple, which means that the death contract terminates and you've got future rights, titles, and interest in this property that they are not selling legally or lawfully or even equitably. Okay? So what happens now is they say possession's 9/10 of the law. Because under common law lien, who has a right to possession? Someone who is owed simple money on a contract, either express or implied. You take your clothes to a dry cleaner's. You leave them, you come back 4 days later. Give me my clothes. He says, give me $50. You go, I got it now. I'll get it later this week when I get my paycheck. I need my suit for a wedding tonight. He says, fine. You come in later today with the $50, you'll have your suit for the wedding. He goes, excuse me, you're stealing my clothes. No, I'm not, sir. The guy calls the cops. The cops come down and they go, what's going on? And you say, you're stealing my clothes. And the cops are rolling their eyes and looking at the proprietor and say, what's going on? Well, he brought it in for dry cleaning. He owes me $50. As soon as he gives me the $50, he gets his clothes. And the cop looks back at you and you say, I object. That's my property. And the cop says, sir, when you get the $50, come on back. You'll get your clothes. Why is the cop on his side? Because common law lien allows someone who has got a monetary interest in the product to hold the product only until he's compensated. So why is it that the sheriff will kick your ass out of this property and put the guy who either bought the property at the sheriff's sale or the trust sale in possession? Because you've gotten rid of the statute staple, they cannot maintain the registered lien on the land. And the only way to give the person who paid the money, who bought your remaining simple contract interest from the bank after your second note, the only way to protect his interest in his newfound lien that cannot be registered. Why can't they register a lien? Why is the sheriff's deed or the trustee's deed not a real lien? There's no security agreement in writing with you. Did you have a security agreement in writing when you took your clothes to the dry cleaners? No, since there's no written security agreement. They got to go off the public law system, which only deals with security agreements expressed, and they got to go back into the republic under common law because you used your note to destroy their statutes. They're following you back over to the common law, and they're giving the guy the remedy at the sheriff's sale, a common law lien, because that's where you took them. Is there any part of any of this process that's illegal, unlawful, immoral, where they stole from you, where they did anything to you, or your straw man? Other than the fact you're going to tell me nobody ever explained this to me. I don't care if they didn't explain it to you. As good trustees, did they steal from you? There's nothing wrong. Stop all this patriotic crap that the bank is a bunch of crooks and thieves. Like Brandon says, we are giving you a remedy. We are giving you private knowledge that outside this room in the public is not available. Stop fighting these people. They are perfect. If you learn to be half as good as they are, your life will go a lot better. Let's take a 15-minute break.